Hi, everyone. Thanks for joining me today. I'm immigration lawyer John Khosravi. Apparently, I've been live maybe earlier. I'm not sure what's going on with the timeline that it's showing on my side, but we're here to do our regular Wednesday, 6 p.m. Pacific. We just went from 5 p.m. to 6 p.m. to discuss U.S. immigration laws and all the questions and issues that are involved with that in a general educational format. So you have better understanding what's going on because this stuff changes a lot. Today's a special episode. I'm on semi-vacation, and so you could imagine my background is a little different than what it's used to. I'm in Carlsbad, California, at Legoland, and so that's a Lego image right behind me. I hope it's not too distracting as we get into all this kind of stuff because a lot of changes are happening all across the world with regard to immigration. I'm sure the question is going to come to go over this kind of stuff. But having said that, let's get it started. Myra asks, how long will it take after being documentarily qualified for an interview in Pakistan? Well, there's no answer to that, but let me explain what that means for the other viewers. Documentarily qualified means the case, an immigrant visa case, a green card case, that's going through the embassy process, also known as consular processing. They initially have to submit a lot of documents to a group called the National Visa Center, and the National Visa Center reviews them, or called the NVC for short, reviews them to see if things are okay or not, if there's anything major missing, before forwarding the application file to the U.S. Embassy in the home country or the foreign country. Now, there's a lot of delays because of the pandemic, and so documented qualified is when the National Visa Center, the NVC, says that we have enough information to move the case forward, and then the embassy is supposed to contact, or through the embassy contact you to say there's a interview time here. But how long will that take? There's no fixed time. It's whenever the embassy's ready. And right now we're just seeing massive delays, unfortunately. So the only thing I could say is, Myra, you have to be patient and hopefully happen sooner, but there's not much power or control we have over that. Ahmad asks, is it okay to apply for citizenship or should I wait of the pandemic? The pandemic has nothing to do with citizenship, so you should do it if it's appropriate. Jeremy, a friend asked, when someone calls in with an I-485 question, what question do you ask to flesh out the facts? Maybe wrong form. It is, but it's okay, Jeremy. This is because I run different programs for lawyers and for regular people, but it's a good question to ask because a lot of people do call me and they don't understand. So for adjustment of status, I mean, first of all, you got to find out if the person is actually in the United States or overseas, because you only file the form I-485 adjustment of status if you're actually here in the United States. So that's the first thing. And secondly, you asked if they enter with permission or not, because one of the basics to adjust status is that you have to have lawful entry, admission, or parole. There's some exceptions that are separate from that, but basically, you want to first find out if they've passed the first prong of the adjustment of status situation, which is if they enter with admission or parole. Once that's done, the second step is to see what is the basis of the adjustment of status. The family-based or employment-based, diversity visa lottery, asylum. There's all these different kind of things it could be. Most of the time, it will be family-based or employment-based. And so then you get into questions of, who's the family member and if it's something they could adjust status. So we have people, for example, who contact who are brothers, or like a brother of a U.S. citizen. They're here in the USA on a tourist visa and they want to file for adjustment status. Well, that's not going to be possible because the brother sister timeline takes 15 years. There's no way they could lawfully stay in the United States for 14, 15 years on a tourist visa for them to be able to file for adjustment status. So it gets kind of deeper, but the first things you want to see is if they enter lawfully, because that denotes whether they need a waiver or not, and then also get into whether they violated their status or have criminal history. So it's a three-prong, okay, or four-prong maybe. Did you enter lawfully? What is the basis of your adjustment of status case? Have there been any criminal history? Have there been any immigration violations? And that will really give you the main ingredients you need. There's a lot more details an immigration lawyer needs, but in a phone call, you could probably get those within a minute or two if the client's efficient and take it from there. But thank you for your question, Jeremy. Historically, I mean, the last couple of years, they changed the work permit form, I-765, so that you could also request your social security number when you're applying in the United States to get it. And what would happen before pandemic was that once the work permit is approved, you get the work permit, the EAD, along with advance parole if you submit it for that in the mail. And pretty much at the same time, the Social Security office would send you a social security number and a card and you get it. The pandemic hit and huge delays happened, in particular for the Social Security office. So that's getting delayed. But just recently, about a month ago, USCIS updated Form I-485, the adjustment of status application. So if you are applying for a green card and are using Form I-485, you want to request a social security card from there, or number, if you a card and number if you don't have it, on the form I-485. But how long it takes really depends on your local social security office. Some of them closed down pretty heavily because of the pandemic and are much slower to respond to anything, like here in Southern California. And others have been faster and more responsive. But I've seen in Florida, for example, it has directly to do with the pandemic and be able to staff the organization. So there's just these kind of delays that we have to deal with, and that's just what we're seeing. So you kind of have to be patient. If you get the work permit and a month goes by and no response from the Social Security office or no letter, you should try calling them, or maybe trying to visit the local Social Security office to see what's going on. Maybe take proof of the work permit, and that way being able to get the card and push it through. But it's just, there are a lot of different agencies at play here working together, so it makes it really difficult. Iman asks, is it possible for a B2 visa holder to adjust status using EB3? Thanks. It may be possible if the case is current, but there's issues with immigrant intent if it looks like you came with a tourist visa to apply. And the timing of the process becomes really hard because within a tourist visa, you usually have 6 months. In an EB3 case, if you start from the beginning, takes much longer than 6 months, could take years. So there's just too many factors to happen. We should really contact, and if you have an EB3 case, you probably have a lawyer your employer does, talk with them about these kind of options, but really get your own attorney is always best, and consult with them in private to see what's going on. You don't want to enter with a tourist visa with the intent to adjust status. That could be considered immigration fraud and be problematic for you. From Saad asks, sir, do you know how I can expedite my I-130 petition? Can I bring my spouse to the U.S. with an emergency visa by showing a doctor's note and my father's death certificate? You can always try to expedite things for humanitarian reasons. I had one case recently where the petitioner, U.S. petitioner, was diagnosed with cancer. We had to fight USCIS back and forth for probably like 2 months, but they expedited the I-130. We got the I-130 completed in 3 months. Now we're going to do consular processing to bring the spouse to the United States, and we're again requesting expedites there. But there's different routes to do this. They get different emergency reasons to come. They're all very difficult to get. There's a lot of back and forth with USCIS. Most of them will get denied right now, but you could always give it a shot. Your father's death certificate, I'm not sure that directly shows an expedite need unless you have, and what the doctor's note says. It depends on what the facts are and which officer's reviewing it, if they're open to it or not. So there's a lot of different factors that go into play here. But try. I mean, at the end of the day, if you want your spouse to be here, you always got to just give it a shot. You just got to be careful what you're saying in those letters, because anything you tell the government goes on the official record. So you don't want to say something that is going to hurt you later. And that's where having a lawyer comes in pretty handy to kind of spot stuff if possible, to be consistent in what you're saying, so it doesn't sound like you can be inconsistent, which should be looked to as you're trying to fabricate something or being disingenuous with the immigration department. But thank you for your question, Sada. I wish you the best. I'm sorry about your father's passing. Yatin asks, they changed my service center. Is that a good thing or no? I get this question every day. It's not something for you to think about, good or no. The idea is that USCIS sometimes sees that one service center, they have multiple service centers that process cases behind the scenes. And if one is too busy, they try to send it to another location so they can kind of get help or have less busy people doing more work. That's the idea, is to make it go faster. Does it actually go faster? No, not necessarily. Does the service center your case gets transferred to make a difference? In reality, no. It always depends on the individual, how they get your case and is working on it, and the facts of your case. So there's two different factors there. And so I have people contact me all day right now saying, oh, my case at Texas Service Center, I'm so worried. How do I move it? Well, you have no power to move it. It's up to them. But just because it's at the Texas Service Center doesn't mean it's going to go faster or slower. It's just something that happens. So what you got to do is just be patient and just hopefully it goes well, and be prepared for the next step. So you jump on that, whatever that is. Kiara I think that's what it says. Can I do volunteer work while waiting for my work authorization to come through? This is a question I get asked a lot, because the definition of what employment is and what unauthorized employment is has been very vague and is interpreted and adjudicated differently depending on which agency you're dealing with and depending on which officer you're dealing with. So it would work for immigration purposes in the United States so that you won't fall afoul of what is unlawful work. I take the most conservative view is that if you're doing something, an activity that an American could do while in the U.S., then that's work and that's a violation. You may be doing volunteer work, like, for example, I go volunteer at a restaurant or something like that, but that restaurant could have hired an American to do that job. So you technically are working You're just not directly being paid at that time. Maybe there's a scheme that says later on when you get a work permit, we'll pay you double to make up for the volunteer work you get. This kind of stuff happens. So I don't recommend people work with authorization and even do volunteer work. Now, for sure, will that be a problem? I can't say that, but it's going to depend on the officer that you're dealing with. And the last thing you want to do while you're already waiting for work authorization, you know it's coming, is to do a violation that can mess everything up. So I recommend people don't do anything that can be construed as work if they don't have a work visa or work status or work permit, whatever it is, when they're in the United States to avoid that trouble. Some lawyers could be less lenient. That's just my interpretation and my conservativeness to protect my clients. But different people do it differently. As you want to take on what the exact details of that work are, just by saying volunteer work doesn't give me enough information. For example, if you go and do volunteer work at a soup kitchen to help the homeless on Thanksgiving, I wouldn't be too worried about that. But if you're going to do volunteer work for Google, and or just some computer company or something, I would have doubts. So it just depends on a lot of factors. You should really consult an immigration attorney if you want to have a more specific consultation and information. Bobby asked, I'm a U.S. citizen. I just sent my I-130 and I-138 for my wife to USCIS. How long would it take for my wife to come? Well, there's no direct answer to that. First, your I-130 has to get approved, taking on average 6 to 10 months. Once that's approved, you have to deal with the National Visa Center. That could take 2 or 3 months or 4 months on average. But then the next question is, when will the embassy schedule an interview time? Some embassies will be fast, some embassies won't be. So there's no answer there. It depends on the embassy. And in about 12 months from now, what in the world's going on in that country, what's going on with the pandemic, and all these different variables that we have no ability to answer. So if this was pre-pandemic and when things are normal and your wife isn't from Yemen or from some country that has issues going on that closes down the embassy, let's say they're from Germany or Japan, probably after starting the case, and if you did it cleanly and no RFEs and stuff, about a year, maybe a year and a couple months, it would be done. They'd be here. As long as your case is done cleanly and your wife doesn't have any particular backgrounds and you're not in a country that has any particular issues with the embassy. But in the world post-pandemic, when there's shutdowns and all sorts of issues like that, understaffing and all that kind of stuff, there's no real answer to how soon your wife's going to come. Hopefully, it won't be more than a year and a half. But if it was, I wouldn't be surprised. And I would tell you that in a consultation, be prepared. There are no answers about timelines. We can only hope for the best, but everything is very slow right now, and the system's kind of stuck. And it's there's usually 50,000 cases in backlog with the embassy system. Right now, last I checked, maybe a week or two ago, there was like 500,000. So there's 10 times as many cases in backlog right now. And so you got to keep that in mind. How are we going to answer something a year in the future now when it went from 50,000 to 500,000, and it's not really getting better? So these are the problems that we have in the immigration system, and that just have to deal with. But thank you for your question. In general, the immigration system right now is at a major issue. I mean, if you see what's happening with the withdrawal from Afghanistan, how messy that is. These are the people that are running the game of the system. There's so many people in Afghanistan who have been waiting for the embassy visa interview for over a year, and all of a sudden they're stuck and undergoing horrible humanitarian situation when they could have had their visas issued, or potentially gotten some sort of humanitarian parole automatically to be able to come to the United States, but they didn't. So seeing how bad the poor Afghanistani people, they don't say Afghani, it's Afghan. I Farsi, I speak Farsi, we could say Afghani. So I'm not sure why there's that big a deal difference what they're making right now. But if it's in English, the Afghan people, if they treated them like that after all the hell they've been for the last 20, 40, 50 years, if you're from some other country, I don't see them treating you any better. But we could always hope for the best. That's all we can do. So we have a question from Facebook user. It says, is the COVID-19 vaccine compulsory for Form I-751 petition removal as resident? So when a person gets their green card based on marriage, and at the time the green card is delivered, the marriage is less than 2 years old, they get a conditional green card. They have to file for removal of conditions, get a full 10-year green card around 2 years later. These new requirement for people getting a green card, the requirement that the COVID vaccine be done and have proof of it, for the most part, there are exceptions, that goes into effect on October 1st. does not apply for removal conditions. These are people who are going to get their green card, not who actually have the green card. And a conditional green card is a green card, so it's not a requirement that you get it for immigration purposes. Thank you for your question. Next question is from Mike. Mike asks, did file I-61A? Can I file I-601 before going to consular interview? I do not want to be stuck abroad. So no, if you file the 601A waiver, you file that before you leave, and then you leave for your interview. That's it, because you can only file the 601 if doing consular processing after you get denied at the interview. So if you go do the I-601A, it's approved, and you go to interview, and for some reason they deny you and they don't accept the I-601A waiver, that is a time then you have permission to file a 601, and you're stuck outside for over a year, 2 years probably. It's a horrible disaster. That's why we got to try to find the best way, any alternatives to not leave. Maybe you have, DACA and you request advanced parole. Maybe you're subject to a thing called 245I, which is an exception. Maybe this, maybe that. It's good to talk with an immigration attorney in private to see if any of these exceptions exist to prevent you from having to leave and go outside the United States, because leaving is a major disaster. I'm immigration lawyer John Khosravi. I'll be back again in the office next Wednesday, 6 p.m. Pacific. I'll start at the right time and take your general educational-based immigration questions there. If you are interested in doing a fiance or marriage green card case, just download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. And so you could really get to know what's going on with the immigration system. God bless you all. Wish you all the best. And hopefully the immigration system won't treat you too bad and you'll get done with it as soon as possible. I know it's a stressful process, and I just see it as my goal to try to alleviate somewhat the stress and pain of people going through it. God bless everyone. Be safe. Have a good one. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.